please spell your name. K-U? All right, thank you. Yes.
My lady, Miss Della will be
Present.
Takes into account all the treaties and conventions that have been ratified that form part and parcel of the law of this country. So those are factors this court needs to address in deciding the sentence in this matter. So, but what then are the objectives of punishment? And again, I seek of your attention because this is very important. The generally accepted goals and objectives of punishment includes but are not limited to retribution. And that entails the punishing of the offender for the conduct, and that punishment be meted out in a just manner. The second objective of sentencing is deterrence. And I'm looking at deterrence in two categories, and that is basically the position. There is individual deterrence and there's general deterrence. And individual deterrence is where the offender is being deterred from committing a similar offense in the future, and the general deterrence targets the public that any other person who intends to commit a similar offense should be deterred. Again, very critical. I'll be speaking to the same as I revert back to this matter. The third objective and goal of sentencing is rehabilitation. I think the word speaks for itself, whereby the sentence aims at giving the offender, the convict, an opportunity to be rehabilitated through designated, designed programs with a view that the offender can reform and be reintegrated back into the society. I'll combine the other two objectives together, and that is restorative and restitution. Those two objectives speak to the offender remedying the wrong in form of compensation. And I would take an order where the court, for example, orders that you have caused harm, and so you need to instead restitute, to bring back the victim to the position that victim was before the offense was committed. I am speaking to all these objectives because we shall be interrogating them and finding out which one is suitable in this given matter. The other goal that we need to address is community protection. And the question the court must ask is this: does the sentence that has been meted out protect the community from the offender? Denunciation. Does the sentence clearly communicate the community's condemnation of the offense? Reconciliation. Should the court order reconciliation, where the family of the victim and the family of the offender sit together and reconcile? And finally, reintegration. Is the sentence of reintegration appropriate, whereby you allow the accused person to go back and be reintegrated? And so, how does the court in the process of this trial deal with the issues, the goals, the principles? Section 216 and 239 of the civil matter says that life imprisonment is 30 years. So the question that one would then ask is, if life imprisonment, and of course it's acceptable, it doesn't mean the life which that person will physically live or be alive. So if it's 30 years and with remission, then we'll be looking at where this court is sentencing the accused person to 30 years. With remission, he serves 20 years and his life moves on. These are issues the court had to think of. I have, of course, taken into account issues of human rights. I've taken into account Article 26, that says a person's life should not just be deprived without good reason. I have made reference, and maybe I should then let you know, to the international instruments that speak, and I need to do this because it's important, to the preservation and the right to enhance an individual's human rights. The International Convention on Civil and Political Rights, which has been ratified and which then, of course, becomes part of our law under Article 2, Sub-Article 5 and 6, says this, and it's important that I read it out because you need to know that. It starts by saying every human being has the right to life. And I stop there and I tell myself as a quote, every human being has a right to life. That every human being includes the victim and the offender. It then says this. This right shall be protected by law. No one shall be arbitrarily deprived of his life. Most of the time when we read these provisions, we speak to them as they relate to the offender. My understanding is they relate to both the offender and the victim. That convention states as follows: that in countries that have not abolished the death penalty, a sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of the crime. So these international instruments that speak to human rights do recognize that there are exceptional circumstances when the death sentence may be inevitable. Let's look at Article 4 of the Africa Charter on Human Rights, on Human and People's Rights, ratified on 23rd of January 1992. It provides that human beings are inviolable. Every human being shall be entitled to respect for his life. His, in my considered opinion, includes her life, and the integrity of his or her person. Again, it reiterates, no one may be arbitrarily deprived of this right. Muratetu reflected again. The Supreme Court says that you can indeed impose a death sentence for most serious offenses, extremely grave. So the question is this a case of serious crime? In answering that question, I considered the following. What the evidence said. And the first thing that was revealed by the evidence is the manner in which the offense was committed. I want to remind ourselves of the judgment I delivered on 9th of February, where I indicated clearly that the evidence of the doctor who conducted the post-mortem report indicated that the person who perpetrated this offense cut the throat of the deceased through and through. in that judgment, I spoke to an understanding that the person was not an amateur. The person must have had some training. And remember, the evidence even revealed that after the offense was committed, the deceased was put in the bathtub and the shower tap was put over to run the blood off. When I read the report presented by the probation department, where the accused person himself says, I have been trained by the Dubai Police Academy and an Ogara group, I thought that corroborates the finding of this court that there was full scale for commission of the offense. I do recall saying in that judgment that the manner in which the offense was committed did not at any time intend to give the deceased 1 more minute to live. I do recall throughout the trial, no any other than the counsel representing the accused person in this trial throughout kept on referring to the incident and the scene of crime as a slaughterhouse. Secondly, we have had the benefit of looking at the photographs showing the body of the deceased and the injuries. I would certainly not display them there, certainly not, at least for the benefit of the family. And I did indicate in my judgment, no one would like to look at them again, not once or twice. Now let's look at, and this is very critical, because it is not the court just making an observation, it was a brutal murder. Let's look at how the defense, or that is the submissions in mitigation by the accused person himself, describes the offense. I will now read to you how they describe the offense verbatimly. They say that it is a tragic, curious loss of life on extreme circumstances bordering on an act of absolute madness that is beyond understanding. So even the defense joins the victim's family and the prosecution and the court in arriving at the conclusion it was a gruesome murder. Horrific, frightening. Let's now look at another important aspect that the court has considered. The consequences of the offense. From where I sit as a court, each one of us is responsible for the natural and the probable consequences of our actions and or omission. So it's not just an issue of committing an offense, but the far-reaching consequences of that offense cannot be ignored. And so in this case, it is undisputed that the deceased was the managing director of the family's business in South Sudan. It is undisputed that the business collapsed after her demise. It is undisputed that that was in, and those who do not subscribe to Christian faith, bear with me. I do, and that's the only place I could make reference to. In the book of Job, chapter 1, verse 12 to 13, this is what is written. I think I looked at the, was it NIV? You can find out, speaks to the same thing. This is what the Lord said to Satan. Behold, all that he has is yours. Only do not lay a hand on his person. I'll repeat. Behold, all that he has is yours and is in your power. Only do not lay your hand on his person. The provision of life is the preserve of God. And I find no room anywhere for a person to take another person's life unlawfully. In my very final conclusion, join me in listening to these wise sayings on murder. 1. In the act of murder, one person's life ends, but countless number of lives are forever impacted. I will read again. In an act of murder, one person's life ends, but a countless number of lives are forever impacted. Secondly, murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. Murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. I have said the accused person before me is 33 years. The deceased was 28 years. Thirdly, the act of murder is a heinous crime that challenges the moral fabric of society and demands justice. And so it is not just a loss to the immediate family. Of course it is in the highest degree, but it's a loss to the society when one is killed unlawfully. And so, based on everything I have said, I have ordered that the first accused person before this court being Joseph Jowie Irungu alias Jowie, shall suffer death as provided for the offense of murder under section 204 of the Penal Code of Kenya. And as that sentence is lawfully set aside by a court of competent jurisdiction. That is the order of the court. Thank you.
and sentencing decision and tax proceedings.